The ADA prohibits employers from discriminating against employees with alcoholism, which is considered a disability. Employers may only test employees for alcohol if they have a reasonable suspicion that the employee is under the influence while at work. A test for alcohol is considered a medical examination. Therefore, employers may only require employees to submit to a job-related test that is consistent with business necessity. Prescription or over-the-counter drugs to treat a disability are protected under the ADA as well, provided a qualified employee can still perform the essential functions of their job with or without a reasonable accommodation, and an employer's drug testing policy should not prohibit such use. Over-the-counter and prescription drugs can be abused and considered illegal, and employers may test employees for such abuse based on a reasonable suspicion. If drug test results reveal the presence of a legal prescription drug or other medical information such as a disability, this information must be treated as a confidential medical record and kept separate from their personnel file. As a best practice, employers should keep all drug test results separate from personnel files to ensure ADA compliance. If an employee notifies their employer that a medication may impair their ability to perform their job, the employer must engage in the interactive process and, if possible, provide a reasonable accommodation that may include modifying job responsibilities. Employers may require employees working under the influence of alcohol or drugs to meet the same standards of conduct as everyone else. An employee with a history of drug abuse or alcoholism whose current substance abuse affects job performance is not protected under the ADA, and they may be disciplined according to the company's drug testing policy. To ensure ADA compliance, employers should set clear drug testing policies that include the type of discipline to which the employee may be subject for a positive test, including termination. Job applicants should understand that any refusal to submit to a pre-employment drug test is considered a withdrawal of the employment application, and further, information related to drug tests should only be shared with supervisors on a need-to-know basis.